Hello, everyone. We are back with you, Chris Land to my right, and Andrea Tinianow. And this is the second part of a two-part session. In this session, we'll be doing a hypothetical, looking at a set of facts and considering the laws.
Yeah.
And
It'll be like going back to law school.
It'll be like, for those of you who just love law school and can't wait, that's what it'll be like.
Yeah.
So we're hoping there's a way to, through the technology, that you'll be able to participate. We're not quite sure because.
Or I'm just going to start calling on random people in the room.
I think that would be good.
Yeah.
Socratic method.
Yeah,
I think that's great. And please don't be shy. This is interactive, and we'd love to hear from you anytime. So let's proceed with that.
Or we'll just call on Russell.
Oh, we'll call on Russell.
Yeah,
okay,
exactly.
Good.
Yeah.
We are going to do that.
All
Okay,
right.
let's go forward. Okay, we've got Frank and Carol. They're both creditors. Frank lives in Wyoming. Keep track of that. Carol lives in Delaware. And we have new funds. They're the debtor, and they are an investment advisor incorporated in New York.
Yep. Very important pieces. I'm just going to break it down for everybody. So
Okay.
we add some more attention.
All right.
Rather thick hypothetical.
All right.
So Frank and Carol are the creditors.
Yes.
You know, they're the people who have,
They have the money.
they have security. Yeah.
Right. They have money first.
Yeah. Frank lives in the great state of Wyoming.
Yes.
And Carol lives in the first state, Delaware.
Yes. Corporate capital.
Yep, corporate capital of the world for a short period of time. Not much longer, I would suspect.
Okay.
And then New Funds is a registered investment advisor incorporated in New York.
Okay.
All right.
Okay. There's going to be a loan, and Frank and Carol each lend New Funds $50,000.
Yeah.
And Frank and Carol each take a separate security interest in 10 Bitcoins owned by New Funds.
Yep.
So there's a question there, don't you think?
Yeah. There's a huge question there. Presumably, New Funds, has a large holding of Bitcoin.
Yeah. Or maybe they only have 10.
Or maybe they only have 10.
Maybe they only have 10.
And in that case, they would be well advised, to think about the financial standing of New Funds and maybe whether they should lend the money or not. But yeah, so let's presume New Funds has 1,000 Bitcoins.
All right.
Okay. And Frank and Carol each have taken security in 10 Bitcoin.
All right.
That's owned by New Funds. And kind of the question here is fungibility versus non-fungibility.
Right.
Yeah.
So the question is Bitcoin fungible, or are you taking, are they taking a security interest in specific 10 Bitcoin?
Yeah. What do you think about that?
I think it really depends on the agreement that they make and their security agreement. If it could be that they're taking a security interest. I mean, we know that all Bitcoin are not alike.
Yeah.
Some have more value than others.
Yeah, they do.
But
at the same time, though, I do think there are some commercial law principles that might recognize the fungibility of Bitcoin.
Right. Especially and maybe under Wyoming law, which has found that it's like money, right? It's so maybe under.
Yeah. I think
without more.
Yeah, I honestly think that is that's one of the things that we might
a new question
look at
in your legislation, maybe in a cleanup.
Yeah, because but fungibility is a question because if it is
if it's any old Bitcoin.
Yeah, if it's any old Bitcoin, they can take any of their 1,000 Bitcoin. But if it's a 10 Bitcoin, it's kind of
they both are taking security interest in the very same Bitcoin.
It's more of a bailment type relationship if they have to get the same 10 Bitcoin back.
Right.
And query whether you could ever get the same Bitcoin back anyway.
Because they're trading it. They're traders, right? They're investment advisors. So, but for the purpose of this hypothetical, let's assume they only own 10 Bitcoin.
Okay.
That makes it cleaner.
Yeah. It
okay.
Does. All right.
Let's keep on going. Okay, so we're going to perfect that security interest. And for those of you, just remind you some first principles about taking a security interest. Between each of the creditors and the debtor, they have their own agreement, and they have a security interest. They take a security interest through this security agreement, and then to perfect it, right? There are ways they perfect it, and that will establish their priority in the event that the debtor defaults. So we have Frank, and Frank enters into a security agreement with New York, and that security agreement is governed by New York law. So they take the security interest via the security agreement, and he perfects that security interest as to any other potential creditor by filing a UCC-1 financing statement with the Department of State.
So why don't you tell the audience, for those who may not be in the secured transaction space, what's a UCC-1 and how do you file it?
Oh, okay. That's a good question. So a UCC-1 is a document that sets forth the name of the creditor, the name of the debtor, and it needs to describe with sufficient particularity, with sufficient detail.
That's a legal term, I think.
Yeah, probably.
Yeah.
The collateral.
Yeah.
And frankly, if you screw up and you put information in there that is materially misleading, that's a financing statement, and then you file it in New York in the financing in the Department of State. But if you file it, you won't know later on. But if it's materially misleading, you basically don't have a priority at all.
Yeah,
you don't get to say I came first. My security interest, it has priority over others.
Yeah. So, but this is a piece of paper, right?
It's largely a piece of paper. I mean, it's electronic.
Yeah.
It can be electronic. It's not always electronic.
Yeah.
But really, it's a dumb document.
Yeah.
You put that information in there, you file it, and then it sits there. And frankly, if the debtor pays back, the creditor, nobody knows anything.
Yeah.
It only springs to action if there's a default, because then everybody looks to see if there's a financing statement filed and who filed first.
Yeah.
That's pretty traditionally what happens.
And there's a database that people search to figure out.
Yeah, there's a database, and so their searches are done, and when there's a lender, a lender, before they lend money, they'll look at the database and they'll say, is there has this debtor been loaned money? Yeah,
are they trying to? Are there other liens on this collateral already, or talk about in all assets too, maybe? Yeah.
Well, I mean, I think that's sort of expanding.
Okay,
that's sort of going a little bit farther than our hypo, but basically, what you put on that document, that tells the world basically what you've taken a security interest in for just that purpose. So that if another creditor comes in and is deciding whether or not to loan money to the debtor, they look to see, okay, who's already taken a security interest in that collateral.
Sure.
All right, so
let's keep on plugging away.
That's just some basic UCC laws. So we have Frank, he perfects a security interest, he files UCC-1 in New York. Now the next day, we have another creditor, Carol, and she enters into a security agreement with New Funds for that 10 Bitcoin, and that security agreement is governed by Wyoming law, but she does something else.
She also helpfully files a UCC-1 with the Department of State in New York.
Right, so let's keep on going.
All right.
And then in her security agreement with New Funds, it sets forth some very important facts, right?
Yeah.
Assertions.
Yeah, one of which is that the 10 Bitcoin are held at a Wyoming bank custodian. The second is that she has obtained a possessory security interest in the same 10 Bitcoin by virtue of placing those 10 Bitcoin in an account
with the bank
in her name at the bank.
Right.
And that Wyoming law governs the agreement.
The security agreement.
Oh, and I missed located too. Yeah.
Yes.
Yeah. So we're gonna break.
Let's talk about. So it says here the 10 Bitcoin are located.
Yeah.
It says who they're located there.
Yeah.
I mean, we're saying that, but would everybody agree that they're located? I mean, everybody is at a universal, or do you think perhaps different people would have different perspective?
Yeah. So one of the requirements under commercial law is that for certain rules to apply, collateral has to be located in a particular jurisdiction.
Right.
And generally, kind of the traditional commercial law approach is that intangible assets can't be located anywhere, right. with certain exceptions, but that's kind of the default rule. Wyoming, in order to avail itself of the possessory security options under commercial law, had to provide some kind of nexus to the state of Wyoming and to deem that digital assets are actually located in the state of Wyoming. And we did that through establishing kind of a multi-part test that was designed to give judges comfort in finding that, there is a substantial nexus between this transaction and the state of Wyoming. And, that also kind of goes back to how virtual currency is more of a bearer instrument, the private key especially. So it's more susceptible of locatability. Is that a word? But it's more susceptible of location than, than a security that's, dematerialized at the depository trust company and the vault in Manhattan.
Right. So. And if I recall under Wyoming's law, if the keys are held by a Wyoming custodian, they are deemed under Wyoming law to be located.
Yeah.
So We can make that. So under Wyoming law, anyway, Wyoming would recognize under this set of facts that the Bitcoin are located in Wyoming.
And that's a box that had to be checked to get into the possessory security interest.
So let's keep on going, because I think the next screen talks about possessory security interest.
All right, we are headed there.
So under Wyoming law, Carol did obtain that possessory security interest because she entered into a smart contract with a New Funds custodian, that Wyoming bank. And the smart contract is administered by the Wyoming bank, and the smart contract meets the requirements for possession under Wyoming law.
Yeah, and there's certain standards that are in Wyoming law that you have to adhere to certain standards, but generally a smart contract is one means of establishing possession under Wyoming law.
Right.
And again, a possessory security interest is most akin to, they have control of the actual asset.
Right.
Yeah.
And that makes sense because the bank actually does have control of those keys.
Yeah. And it also prevents the debtor from,
taking it back.
Yeah.
And using it to give to someone else.
Yeah.
Okay, let's keep on moving here.
All right.
So now there's a problem, because there is always a problem in a hypothetical.
Yeah.
And just what you thought.
Yeah.
Just what you thought. The Carol and Frank are not going to get repaid.
Yeah.
And
there's not enough money.
There's not enough money. There's a default. So so New Fund defaults. And what does Frank do? He sues in New York State court, and he sues New Funds. So Frank proves to the court that he has perfected security interest. After all, he filed that financing statement, and there were no other financing statements on file that were earlier in time, because if there were, he would lose. Yeah. Right. Potentially he would lose.
Yeah.
So
there could be, misleading information in the UCC.
Yeah, of course there could be, or there could be someone with greater priority interest.
Absolutely.
Yeah, priority. So New Fund is defending, and during the defense, they say, wait a minute, there's this competing security interest held by Carol, and Carol has the same security interest in that same collateral, that 10 Bitcoin. So
and again, New Funds only has 10 Bitcoin.
Only
has 10 Bitcoin. So
there aren't other Bitcoin to come in where the court says you get 10. You get 10.
And this is also assuming that there aren't any creditors that have higher priority.
Right.
Than
Other
Carol
ones.
and Frank.
Well, there could be.
Yeah. There could be.
It could be federal government with taxation
or OFAC issues
or child support or something.
Yeah. But for the purposes of this hypothetical, there's 10 Bitcoin. There's going to be one winner and one loser that's made whole. There's going to be one winner that's made whole and one loser that goes home with nothing.
And I hope all of you, we can't see your faces, but we hope that all of you are thinking about who you think is going to win, because we're going to be calling on you.
Yeah.
All right, what's next here?
All right.
So what does Carol say? She appears and she argues that she actually has a valid security interest in Wyoming law. It was perfected. She filed recall in New York.
Yeah.
And also she perfected by having a possessory interest under Wyoming law.
Yeah.
So she argues that even though her security interest was perfected after Frank's, because her perfection was by having a possessory security interest in that Bitcoin, it takes a priority under Wyoming law.
Yeah.
Even though she's in the New York court.
Yeah.
Yeah. So let's see what happens.
All right.
Let's go to the next. And so the question is, who wins, Frank or Carol, and who has priority? Can we get a show of hands of who thinks Frank wins? We got a thumbs down. We have no, I only see 6 faces. Oh, 4 faces, but maybe, how about this? Give us some reactions.
Yeah, you use the thumbs up button if you think Frank wins.
If Frank wins, use your thumbs up.
Yeah.
Okay. If you think Carol wins, use your thumbs up. Oh, we got a couple.
Yeah.
We got a few. We got 3. We got a bunch. Oh, we got lots of them. Okay. Well, cool. Can we call on you? Can someone speak up? Why do you think? If you think Carol wins, tell us why you think Carol wins. Come on.
Take a stab at it.
Okay, great.
Sure. Brendan Marr here. I believe that she has won because she has perfected a direct case for direct control over that asset.
Okay, so are you saying that that because she had a security interest, a possessory security interest under Wyoming law, is that, or you put that all aside and you're like, possession is 9/10 of the law. She's got the possession. She should win.
No, what I'm saying is it's 1,000% of the law in Wyoming.
Right, but she's in a New York court.
Yeah, she's in it. Yeah,
she's in a New York court.
They're in a New York court, but Carol's the New York court might be applying Wyoming law.
Is that what you're saying? You think New York will apply Wyoming?
That's what I'm saying. Sure.
Okay, cool. Okay, great. Can I hear from someone else, please? Who else wants to jump in? I'm saving Russell for the end.
Why don't we call on Sam Laffey? He's a recent law school graduate from the University of Wyoming.
Wonderful. No, just so you know, this is cutting edge. This is absolutely, there are no right answers. There are no wrong answers.
I really am enjoying it. I should become a law professor. I really am enjoying this too much. Yeah.
All right, Sam, unmute.
All right. Good to see you.
So who's going to win? Who's going to win, Frank or Carol?
I think Carol's going to win.
Okay. All right.
All right. Tell us why.
Possession.
I think the state of New York will have to grudgingly apply Wyoming law because that's where the contract was signed and that's what the law of the contract will be governed under.
And does it concern you though that that Frank filed first and was unaware of Carol?
No, but I didn't do that well on secured interest on the bar exam. So, but we'll see.
No problem. Okay, is anybody concerned about that? Frank filed first. He didn't know about Wyoming's strange new law?
And does it concern anyone that Frank actually lives in Wyoming?
Hey, that was the sleeper.
Yeah.
Okay, who wants to speak up? Can we call on you? Who wants us to call on them? Jade. Eric.
Yeah. Jade.
Yeah. Okay, Eric, you're gonna speak up. Tell us what you think.
Well, we have a security agreement that states it's governed by Wyoming law. So I don't think a New York court is going to have a problem enforcing it. But you asked, am I bothered by the fact that Frank perfected first? And in effect, he had no means of determining whether or not there was some other security agreement. So the answer to your question is yes.
So Eric, I would respond, you said he has no means, but he could have asked for the keys, right?
So that he could control it? Sure.
Yeah, right.
And I would agree. There might be an equitable argument that under New York law, if you read New York law, all I need to do is file that UCC.
Right, I checked. And there were no other financing statements on file.
Yeah.
It's not my job to do.
There could be an equitable argument potentially.
Jade, what were you going to say?
Oh, no, I'm mostly a technologist. My co-founder is kind of deep in the blockchain space.
Oh, okay.
And stuff.
Okay.
I'm just coming up to speed on some of the securities, stockbroker sort of stuff. And then our business units include a transfer agent. So my questions are not coming from a lawyer or my
That's okay.
And Jay, believe me, like 90% of lawyers, hope to never have a UCC question that they have to deal with. It's quite.
But if I remember, Carol's Frank's security agreement was under New York law, right? I mean, Frank's security agreement was under New York. I mean, Carol's was under Wyoming.
Yeah.
But Frank's was under New York law. So Frank thought that he didn't. Why does he have to think about anything else?
Yeah, and see, that's a very interesting question because you can make arguments on both sides potentially. Like Frank could say that I did everything under New York law.
That I was supposed to.
This is a New York court,
right? I get the proceeds.
Yeah, but at the same time, though, on the other hand, Frank's a Wyoming resident. He knew or should have known that Wyoming law applies differently to digital assets potentially. Right?
And the other thing, it's not like Wyoming is keeping this law secret, right? No. And the other thing is this is a new digital asset class, right?
Yeah.
So it's not, and UCC, it's called uniform. It's not a federal law. States pass them. Yeah. So it's not as if all the states could start suddenly passing this law. But actually now I'm going to ask a dear friend, what does he think? On the one hand, on the other hand, Russell, can you jump in here for us, please?
Well, I'd be happy to.
What do you think? Tell us what you really think.
My instinct, and this is only an instinct, because I think there are some very novel questions raised by your hypothetical. My instinct is that Carol does win in the New York court. But it's not a slam dunk.
It's not a slam dunk. Okay.
It's not a slam dunk, and I think Frank does have some very compelling arguments. The main one is that under Article 9 of the UCC, assets are presumed to be perfected by filing unless they fall into other categories. So filing is the means of perfection of first resort. And what we have here is a question of priority. There's no question that both of these people lent money to new funds. There's no question that they attached or created their security interest, and there's no question that they perfected. The question is who has priority. And when it comes to priority, the UCC says that unless one of these other special factors is present, the law of the debtor's location, which is New York in this case, that's where New Funds was incorporated, the law of the debtor's location determines perfection, priority, the effect of perfection and non-perfection. Now, a special exception to that exists for goods and other tangible property that is located in a jurisdiction. The law of that jurisdiction governs the perfection and priority of a possessory security interest. Now, New York does not consider Bitcoin to be a tangible object. It's not money. It's not goods or inventory. It's an intangible, and an intangible cannot be perfected by possession. So unless you can assure that the door into Wyoming law, there's no reason why New York would ever look at anything other than the filing as a method of perfection. And when it comes to filing, as you know, the rule is first in time is first in right.
Yep.
Frank was the first to file and he wins. So the question is, could you necessarily persuade the New York court that even though this thing, Bitcoin, is not something in which a possessory interest can be taken under New York law, it can be taken under Wyoming law, and Wyoming law is relevant here. And the reason why I think Carol wins is precisely because Frank is a Wyoming resident. And he could have, I think equity marches in here. And if I were the judge, I'd say, you of all people, Frank,
unclean hands. He's coming to the court with unclean hands.
Unclean. Well, I don't know if it's unclean hands, but you of all people should have known better. You could have done more to take this possession. That's why my instinct is that Carol wins. But it's not a slam dunk, because you have to get a New York court to characterize the asset as something that it isn't under New York law. And it's complicated by the fact that even Wyoming law, even the Wyoming appendix, calls it an intangible asset, which helps Frank in his argument to the court that even if you look at Wyoming law, it's still an intangible. And as far as New York is concerned, you can't perfect an intangible by possession. You only perfect.
Russell, would the argument be strengthened if Wyoming were to modify the law to create a separate category? That doesn't even make sense, really. Of course, you wouldn't want to create a separate category outside of intangibles, right? I mean,
but the default is possession only applies to tangible goods.
Right.
That's in the comment UCC.
Yeah.
So yeah, but on the other hand, Russell, why don't you talk a bit about Carol's standing, because she's applied. What would be your view about a New York court applying Wyoming law to Carol, since she's availed herself of Wyoming law? Would a New York court apply Wyoming law to Carol?
Well, to her contract, she chose Wyoming law for an asset in Wyoming. I don't think there's much question that a New York court would apply Wyoming law to her contract.
Yeah.
The question in my mind is whether they would, because remember the UCC says that when goods or collateral is located in a state, the law of that state governs a possessory interest.
Yeah.
The question is would they look to Wyoming to decide whether this is whether Frank had a possessory interest?
Yeah.
And because if he did, he should have perfected it by possession.
Yeah.
You know, if this is that kind of collateral.
Russell, I have another question for you. We talked briefly earlier about the fungibility or non-fungibility of digital assets like Bitcoin. Do you have any thoughts about how that might be treated in a UCC1, or just the general nature of the fungibility of digital assets?
Or should it be?
Yeah.
Well,
I mean,
I would point out that,
or even if whether a UCC1 is the right vehicle for defining a specific Bitcoin in UCC.
well, that's an issue that exists with many classes of collateral. It's not just Bitcoin.
Yeah.
If you take a security interest in inventory, let's say 6 tons of grain, and the debtor has 12 tons of grain, which 6 are yours? If it turns out that 6 tons of grain are rotten and 6 tons of grains aren't, how do you say my security interest was in the good grain? Right?
Of course, it always
so
was.
This is the same, when you have shares of stock and they are certificated and their certificate numbers, you can address that. So I would say that if you want that kind of certainty, and if there is a way using source codes or whatever of identifying precisely which Bitcoin you're talking about, then maybe that's a good idea. But if New Funds is a Bitcoin trader and they're constantly recycling Bitcoin through their custodians, then it's dangerous to pinpoint exactly which Bitcoin you have.
couldn't do it.
Just the way it's dangerous to pinpoint exactly which grain you have your lien on, because it's going to recycle out and you'll lose it.
Yeah, we have a question. Jade has a question, but you have to unmute yours. There you go.
Yeah, I was just going to say, there are the possibilities of having colored coins. Are you guys familiar with that phrase?
No. Why don't you tell us about it?
It's basically, you know, and I'm not the right expert for this, but I have heard, and my founder, sorry, he's not here, he's at another thing, but that you can have colored coins so that they are not fungible, that they mean like, hey, I've colored this with some blue or red or green, and this is an identifiable thing in the world. But a lot of times people don't want to have that identifiable coin. They want to be able to lose it in the exchange or that sort of thing. But you can technologically have a colored coin.
Interesting.
I can shed some light into this.
Sure,
Yeah, go ahead,
please.
Brendan. Yeah.
If anyone is interested. Okay, so the first thing we have to clear up is the fact that coins don't exist because they really don't. Okay, a wallet doesn't actually hold any unique coin. It actually just holds signatures, and they're all summed up. It's basically, a wallet is really a mini micro blockchain. So your copy of the blockchain is actually in your own personal wallet, metaphorically, or not metaphorically. That's the way it works, right? So the coins, your value of a coin is summed from various transactions. So this idea, perfecting an original coin, it's just not possible. Regarding the other idea that Jake.
He's so excited he fell right over.
We may have lost Brendan. I'm gonna vamp a little bit and say I disagree with his characterization. Brendan, I disagree with your characterization a bit. I think from a legal perspective, you can have a divisible asset, and that's kind of what we're talking about when we talk about coins. But I think from a technological perspective, you could very well be right.
Okay, that all makes sense to me. That's fair. But to get to quickly Jade's comment about the colored coins, what she's, I think, getting towards is this newer construct, which I'm sure you're all aware of, which are non-fungible tokens, which is essentially what she's describing.
Got it.
Yeah.
Does anyone have any further thoughts or questions about Russell's comments? Because I think
I do.
Yeah, please.
Yeah, so it sounds to me the ideal situation is to have the contracts in the jurisdiction of Wyoming and to have the debtor in Wyoming. That would be the best case scenario all around. Is that correct?
Well, then you'd have clarity, right?
Yeah, you would have
You really wouldn't have an issue, I think.
You wouldn't have any issue then.
You wouldn't have any.
Sounds
issue.
like sounds like a strong case for Wyoming as jurisdiction.
Yeah, I mean, if Carol had sued in Wyoming, you might have had a different outcome. Clearly, I mean, I think the issue here really is sort of the way the UCC works and the fact that the states, and that this is a new digital asset, a new asset class, frankly, that people are recognizing it has value, but the states are really now coming to figure out how do we want to handle it, and there isn't uniformity. But I think what's really interesting, there's actually a case in federal, I think it was federal court, an appellate decision, which decided to not recognize a Texas law, maybe Texas and Utah, but there was a law that gave priority to folks in the oil industry, and they said we're not going to recognize this law, and largely my take on this case was that the state said that the court said, why should there be priority? Priority should be given to these creditors when nobody knew about the law.
Yeah,
there was like a secret law for people.
It wasn't secret.
It wasn't secret, but it had the effect. It was a law that gave a priority to folks who had a security interest. I think it was sort of oil drilling and drilling equipment and the oil that came out of it. And clearly it was to help promote the oil industry in those jurisdictions. But the court came away and said, listen, I know that's what your state law says, but you're not going to have priority. We're not going to give priority. So it was looking to another state's law to decide whether they should follow the priority, the effect of the priority law. And the court said, and the court said no. And I think what's really a distinguishing factor here in Wyoming is that the fact that we are all on this webinar, the fact that Chris is out there talking, day and night to regulators around the country, around this country, state and federal, and they're writing articles and they're just out there pushing this out there. They're involved with the ULC. They're working with the ULC, the Uniform Law Commission. By no means are they keeping this a secret.
Yeah.
To the contrary, they're doing everything in their power to say, we think this is the way to go. We think this is the best practice, and really using this as a teaching moment for everyone.
So, and the main reason, I think the main way that Wyoming's laws, commercial laws governing digital assets would actually come into play, everyone's heard about Wyoming's new bank charter, the special purpose depository institution. Kraken got a bank charter last week from us. It's been in the press pretty widely. That is probably the main use of these laws. And I don't know that there would ever necessarily be as much of there could be potential conflicts, but the way these laws would probably be used more clearly and more distinctly is from our position as a banking regulator, making sure that the banks are managing their legal risk. And if an SPDI were to fail, we would be the receiver of that particular failed.
And you'd have to figure out who gets what and who has priority.
And it would be left in our office's hands to determine who has a possession or priority, because under the federal bankruptcy code, banks aren't subject to the U.S. bankruptcy code. So it would come down to Albert, who's the banking commissioner, and me to determine who had perfection and priority. There would always be a challenge in a court after the fact, after we had made a decision, but we would get administrative deference and all that other stuff.
So guys, thank you. That's really helpful. That's really interesting. We actually have a bonus hypothetical for you.
Yeah.
Because we thought this was pretty complicated, and we really thought we were going to talk about it for an hour, and you guys are just too smart for us. And, so here's our bonus hypothetical. We don't even have a PowerPoint. It's really, really quick.
Yeah.
So here's the second piece. Now, what if New Fund, instead of using a Wyoming bank, what if they had used a trust company, a Wyoming trust company instead, instead of an Stampede bank? And what if that trust company only provides, traditional custody? They don't provide any fiduciary services. So they're a traditional custody. They hold things for people.
They provide safekeeping services.
They provide safekeeping services, and now they're providing safekeeping for keys.
Yeah.
Perhaps through smart contracts, but perhaps not.
Yeah.
So, so the question is, can this trust company be a qualified custodian to New Funds?
Yeah. Yeah. So
first of all, let's ask the.
Yeah. Okay. Who thinks? Let's not do the hand raising thing again because it didn't work that well. But if anyone has any comments on what they know about custody and qualified custody and trust companies versus banks, we'd love to hear it.
Does anybody have any ideas? And granted, we didn't give you the law ahead of time. We're just throwing this as this bonus hypo. So
Well,
okay, Brendan, tell her.
given the task force meeting yesterday, I would say there's a lot to be said on this. I think the way it's going to play out is that we don't actually have the right instrument to do this correctly in terms of the right kind of trust. What I do find interesting, I'm going to ask you. Why don't I ask you to repeat the question first?
Yeah,
before I go off on a tangent.
Yeah. So there's a lot of hype. You know, if you take 5 seconds right now and you go into like you Google like qualified custody in crypto, you'll pop up a bunch of trust companies that say they're qualified custodians under the SEC custody rule. The reason it's important is because qualified custody, when you're an investment advisor and you do certain things, you have to use a qualified custodian. And it's kind of seen as like the highest level of custody in
Right.
space. The question is, should you use a bank or should you use a trust company? And
Or
what's the
can you
difference?
use
or can you?
can you use a trust company to be a trust company serves a qualified custodian under federal law. That really comes down to it.
And also, why don't I take a second and explain for the non-banking crowd here what the difference between a bank and a trust company is, because there is one very important.
Sure.
A bank takes deposits. And a deposit under the law, at least under the UCC, is, when you swipe your debit card at McDonald's, you're taking money out of your deposit account, probably a checking account at your bank. And deposits, interestingly, are, kind of in the same way securities are a little bit. They are liabilities of the bank, right?
Sure.
Yeah. They're liabilities of the bank, but the bank actually takes title to your assets. A trust company is not permitted to receive deposits. It only provides trust services and safekeeping services. So you can't swipe your debit card and spend money at your trust company account. Now, I will say for the banking crowd here, that there are some trust companies in states like New York and Massachusetts and some of the other northeastern states that are permitted to receive deposits. It's kind of a historical figment, but most non-depository trust companies don't receive deposits. And that's a key difference.
Okay. So, but there is, so if we're going back to this, the question, can a trust, you're saying the difference between, and the question is, there are some missing facts about what it takes for a trust company to be a qualified custodian, right?
Yeah. And so this all boils down to, I guess this is going to turn into more of a lecture than anything else. But I'll try to.
Can I take a stab? Well, I know what it's related to.
Okay. Go ahead, Brendan. Yeah.
I find my understanding about the way SBDI was engineered was quite interesting in terms of the whole Baylor relationship and how it doesn't fall under the requirement of needing FDI insurance because it's under Wyoming jurisdiction, and you get away from all of those issues. So there's this very interesting piece in the engineering of all this related to the ownership of the asset, and that's really the crux of the whole matter.
Jump in because I think actually we want to take a different route here. I know where you're going. I think the question that we're looking at is the trust considered a bank under the Advisors Act? Isn't that really what we're looking at here? Because the Advisors Act has some pretty important language, which really, that's really what you're going to say whether or not it's considered a bank. And it has to do with something very important. I'll let you.
So everyone thinks they know what a bank is, but I will tell you that under state and federal law, there's at least 150 different definitions of what a bank is.
But the only one that really counts for this purpose is
the Advisors Act.
The Advisors Act, right.
Yeah, in federal law, the SEC Investment Advisors Act. But interestingly, there's many definitions of what a bank is, and it's very challenging. And there's a whole lawsuit going on in New York right now that if you're interested in this, you should look up Lacewell v. OCC and read that case because it's fascinating. It's going to determine in a lot of really important ways what a bank is in
But
the US.
that doesn't really impact us here.
Yeah, I was just
But
giving them.
that is a good tangent.
Yeah.
And I really do recommend that opinion. It's an interesting read. If you're here today with us over your afternoon or your lunch, you will enjoy reading the opinion as we do.
Yeah.
So.
But anyways, under the Advisors Act, a bank, a trust company can count as a bank if they're doing certain fiduciary activities.
They can.
Yeah.
They can.
They can be, but it has to be a substantial part of their business.
Right.
And so the next question is,
what does it mean
to be a fiduciary?
What does it mean to be? Can you be a fiduciary if you enter into a contract?
Yeah. Yeah. I mean, can you be a fiduciary just by virtue of providing safekeeping services? For if I loan this to Andrea and she promises in some kind of bailment to safeguard,
I promise that I will take care of it and I will consider your best interest as I hold on to your keyboard. Does that mean I'm providing fiduciary services? I would say probably not.
Probably not, because you're not exercising discretionary authority.
Right.
But on the other hand, if I give you this and ask you to go use it to make money,
take this and figure out how to make money using this. Now I've used my discretion.
Lend it out to other parties to use.
Right.
Use
then
that keyboard.
maybe I am.
Because you're exercising discretion in who you loan the keyboard out to. So that's an interesting question.
I've got a note here.
Okay.
Right.
Yeah.
Yeah.
So if you have a trust company and they're taking, they're holding they're providing custodial services and nothing more than that.
Yeah.
Then they probably aren't going to be a considered bank.
At least under the Advisors.
At least under the Advisors Act.
States are totally free to define how they,
But there is another authority.
Yeah.
The OCC. Hasn't the OCC sort of?
Yeah, they've clearly said.
They've clearly said.
Yeah. But
that custodial services alone does not make you a fiduciary. That's the OCC.
Yeah, and the OCC's granted deference in the definition of bank in the Advisors Act.
Right.
So the OCC's word is important, but
Right.
States are still free to define what a fiduciary is. But in the context of the Advisors Act, there's real risk and real doubt about whether a trust company that's not a fiduciary is able to act as a qualified custodian.
So based on these facts and this discussion, a trust company that provided custodial services alone and did not have discretion over their clients' assets, that they probably could not be considered a qualified custodian.
But I think it's legitimately up for debate.
It's up for debate.
But I think the law favors one side, but reasonable minds.
And frankly, there are going to be a lot of folks on the trust side who are going to argue otherwise.
Yeah.
Because there's a lot of money in this.
Yeah, but on the other hand, though, like the SPDI, Wyoming's new bank charter, and traditional banks, like the community bank down the street or JP Morgan, they clearly fit the definition of bank and are able to provide qualified custody services. Now, Jade, you have an interesting question.
This becomes really interesting. Okay. This becomes.
Please.
This becomes very interesting when we talk about data and whether that data is just being held by key or it's actually being used to generate revenue, right?
Yeah, and I think data is a totally, Brendan, I'm sure you watched the select committee testimony yesterday afternoon where there was a long discussion about what data is and whether you can monetize it or not. I think we're having a more narrow discussion about digital assets that are, more financial assets instead of data more broadly, because as Professor Reyes pointed out helpfully that you have some exclusion issues when you come to just data itself, data that's sitting on my hard drive. There's some different property law issues.
Right.
Jade, you mentioned something in the text box. It's interesting, and being a bank regulator, I'm going to kind of let you in on why the Minnesota Department of Commerce may have said that to you. So Jay's comment was, in Minnesota, the Minnesota Department of Commerce, which is a great agency. I used to live in Minneapolis and went to the University of Minnesota. Side point.
We just fired the commissioner on my birthday.
Wow. So the Minnesota Department of Commerce wasn't so keen on Jade's company calling themselves a bank.
Oh, and can I just jump in here? Because in Delaware, you cannot use the word bank in the name of your corporations. It will be rejected by the Division of Corporations.
And it's actually
just so you know, it's a loaded word.
It's actually the same way here in Wyoming. Anytime someone uses the word bank or trust in a corporate filing, it comes to our office, and we have to sign yes or no whether they're permitted to do it or not.
Yeah.
But the reason why bank is such a loaded term is that bank has the public understands banks to be heavily regulated entities that take
And a place of
deposits.
trust.
And a place of trust.
Trust. So if you use that word bank, then there's trust imputed into the company.
To get a bank, you have to do all these things that I'm about to name, and it's like a 12 to 24 month process. You have to
We've been
post.
looking at purchasing a regular bank. It's probably 2 years out for us.
Yeah, it'll definitely take that long. Bank transactions take a long time.
Yeah,
But,
we just got through our broker dealer. That was 120 days.
Yeah. But yeah, banks have tons of capital, and they're managed in a certain way and have policies and procedures, and they have a certain level of trust. So regulators are very, very persistent and very finicky about who they allow to call a bank. You have to go through the whole process and have a charter, which I'm sure you know. You can always buy a bank.
Yeah, that's probably what we'll do.
That's a long process too, that requires your state regulator and your federal regulator, if applicable.
That's why I'm curious how things are going in Wyoming. It might be a little more favorable than Minnesota.
Yeah, we do have several banks for sale. I'm sure you can find out who they are pretty easily.
Anything under 3 million?
What?
Anything under 3 million?
No, no, definitely not. Yeah, so very particular about who we allow to call a bank, because the public, places trust in them, and they know that they're heavily regulated and stuff. So that's the reason. Every banking regulator in the country is the same way we are too. So
yeah.
So I don't have any other questions for you, Chris. I don't know if anyone in the group, Russell, yes.
Yeah. At the risk of backtracking, I'd love to go back to a couple of things on your first hypothetical.
Okay.
Okay, we got a few minutes. We're game.
If we have a few minutes.
Sure.
One of which I think takes it down to more of a micro level, and one that takes it more to a macro level. On the micro level, one of the many reasons why I think it's not a slam dunk in favor of Carroll is that we're dealing with individuals rather than companies as creditors here, which means that these are at least arguably consumer transactions.
Yeah.
And when that happens, all kinds of consumer protections and consumer laws come in, including kind of state ring-fenced issues where states frequently will draw a fence around consumers in their jurisdiction.
Sure.
Yeah.
And say,
so they want to protect. So that's a great point. So if instead of Carroll and Frank, if we had come up with Carroll Co. and Frank Co., you would feel more comfortable with the assessment you gave earlier.
They're more sophisticated.
They're more sophisticated, and they wouldn't be covered by the consumer laws because they would be.
That's right. So that's sort of bringing it down to the micro level, and I wanted to make that observation. And I'd also like to say that in the scenario that you set up, Carroll has sort of a perfect case for herself because there are so many contacts with Wyoming.
Yeah.
But the custodian is in Wyoming, and the contract is under Wyoming law, and the security agreement is under Wyoming law, the smart contract and the key, all of that is Wyoming, Wyoming, Wyoming. And even in New York, the Empire State, with that many contacts, it's not hard to persuade a court that Wyoming is proper. But I would put forward that in the standard commercial transaction, it's usually not quite, there are usually contacts all over the place. And then to raise this more to the macro level, I'd like to propose a sort of international dimension to this. And that is, because it's what I do for a living.
Yeah.
But as we have more and more international investors in U.S. markets and vice versa, you will run into situations where it's a court in Germany that is deciding this, where or the laws. And you're going to have a mixture of many different factors and many different laws. In those countries, in many countries, the distinction between the attachment, the perfection, and the priority of a security interest doesn't even exist. It's like kind of all or nothing. Yeah. And if you didn't make certain filings in Belgium, then a Belgian court isn't going to give you any respect. The Uniform Commercial Code is called uniform for a reason. And that is, up until the late 50s or early 1960s, I don't remember when, this is history even before my time, every state had its own laws dealing with security interest in property. And it was felt that it was really inhibiting commerce in the United States by having these disjunctions. And that was when the Uniform Commercial Code was devised. We always assume that the UCC is going to be identical from state to state, and it is not.
Yeah.
But
Not
it
at
is
all.
not at all. But but it does have certain guidelines, and that you can sort of count on in certain concepts that you can sort of count on being being there in different states. While I personally applaud heartily what Wyoming has done, and I think it is an example to other states, it is kind of going out of step with what the UCC was meant to be. And I think,
but Russell, I'm going to jump in here because what I think is very, very important. You're absolutely right. But on the other hand, this is really, this is quite new to have a whole new asset class, whole
Yes.
new and very different from anything that's ever come before it. So yeah, you have the idea that it's supposed to be uniform, but how does something get to be uniform when every state, has, so it does take a little time.
it takes time. And I say the takeaway for me is that all of us, especially in the major financial centers like New York, North Carolina, California, have to stop assuming that the way we think is the way things are everywhere. We have to take a much more national and even much more global view. And even if perfection by possession of a key is not the way you can do that in New York, if you don't do it, you're opening yourself up to litigation risk.
And the courts aren't necessarily going to help you. And I think that's what you were saying.
And the courts will not necessarily, I mean, they might, but
know better.
it's based on a lot of technicalities.
Right.
And you're opening, especially if you are a sophisticated creditor or sophisticated investor, you're opening yourself up to litigation risks if you're not mindful of what's going on in.
Or perhaps if you're lawyers, you're opening your lawyers to your advisors to risk because they should have known and they should have advised you. Jade, we have a question from you. Please jump in.
Yeah, I was just going to kind of pile on what Russell was saying. I am personally and professionally very interested in trying to put together some of those standards that if we're setting something here, that it will be compatible with other countries. But, I'm deeply technical, but I'm essentially ignorant. It doesn't even occur to me, like, who is the securities supervisor of Belgium? I literally do not.
Sure Russell can tell you.
Yeah.
I'm sure you we'll have to connect you offline.
And there's a European regulator that
it's the EU. The EU has a commission.
So I'm on a transfer agent blockchain standards group, and we're right now trying to put together what we think makes sense for companies in the U.S. But we want to be intentional to match up with the banking industry, match up with, what other countries are doing. If there's something that we could go one way or the other, let's make sure it kind of lines up. So I would love to connect offline.
Yeah.
Great.
Yeah, we should kind of figure this out because I'd like to connect with you.
Yeah. I think I already
get everybody connect with each other. Maybe we can circulate. We'll talk
chat
to
Thank you.
Yeah.
I mean, if people want to friend us on LinkedIn, we can just
just find us on LinkedIn and we'll get you whoever you need. We'll make sure to do that because we're both you know how to reach us.
Yeah.
We have a couple of minutes. Does anyone else have any other comments or thoughts they'd like to share?
Yeah, so we'll give you back a couple minutes of your time so you can go to your next session. But I really want to thank everybody.
Yeah,
Russell,
thank you.
Russell in particular, you were a fantastic resource in preparing for this, and really want to appreciate you spending your time out of your busy day.
You. Thank you so very much.
You two set the standard. So thank you for your insight.
Thanks everybody. Take care. Have a great weekend.
Thank you.
Bye-bye.